So, of course, when I say out indefinitely, doctors note that these take different forms. Sometimes they'll say the employee will remain out until further notice, or the employee cannot return to work at this time. Sometimes, among other things, they'll say that the return date is unknown, or something like the employee will be evaluated at their next appointment, and there may or may not be an indication of when that next appointment is going to be. This can be frustrating for employers, especially the supervisors who are trying to make sure they are properly staffed and possibly have already been dealing with somebody who's been out of work for a while and they just want somebody reliable back in there. But again, there are legal obligations to consider, and while the employee is certainly not entitled to unlimited leave time off, they may be entitled to some more time off, and the company's responsibility is to figure out whether they are and how much time that would be. On one hand, the employers, of course, do need the reliable staffing and can't hold positions open forever. But not every out indefinitely type of doctor's note means that the employee is going to be out for a long enough period of time that it wouldn't be considered reasonable to allow them some more time to recover, especially under the assumption that the employee is not being paid for this additional time. So courts have generally recognized that a finite period of leave can be a reasonable accommodation under some circumstances. For example, if a doctor says the employee will likely be able to return in 4 weeks, that gives the employer a tangible time frame to evaluate. It's the indefinite, open-ended, or long duration scenarios that become more problematic. Granted, in some cases, 4 more weeks certainly seems like a burden, but often the employee is going to be entitled to that period of time as an accommodation once you do the analysis, unless their role is so critical and the only way the company can move forward is to replace them permanently. Many employers wonder, well, how long do I have to let the employee stay out? And of course, the reality is there's no bright line standard here. It's what's reasonable under the circumstances. Many employers have policies that say if the employee's been out for 6 months or 12 months, then we are going to terminate if you don't return. Those policies, especially by the EEOC and the New York Human Rights Agencies, have been deemed potentially unlawful, especially if they're applied rigidly. Even at the end of those periods, the employer should be making some analysis of when and whether the employee would be able to return. If you've allowed someone to be out for 6 months or 12 months and they can return in 2 weeks, then it may be considered unreasonable to deny them an additional 2 weeks off. So, what should the employer do? Well, the employer needs to engage again in the interactive process and get more information. In these cases, it's pretty common that you need more information from the doctor. You can ask for more information. You can either ask the employee to sign a HIPAA release and communicate directly with the doctor, or often it's easier just to give the documentation to the employee and say, I need you to provide this to your doctor and have it returned to us. The type of information that you're looking for can depend on what information you already have. If you know someone has been out for knee surgery and they're recovering from knee surgery, it may not be as critical to ask for things like their diagnosis. But in other situations, the employer doesn't have much information on what the medical condition is, especially if there hasn't already been FMLA leave with certifications submitted, but you do have the right as part of this interactive process where relevant to find out what the diagnosis is so you can make your own evaluation as to whether it's really reasonable to allow this person more time off for work from work. One mechanism that employers will choose to use at this juncture is to provide a copy of the employee's job description and ask the doctor to comment specifically on what the medical condition prevents the employee from doing. This could reveal alternative approaches to accommodating the employee without extending the leave. So it's not always the case that the employee is entitled to the accommodation that they want. They are entitled to a reasonable accommodation that will allow them to perform the essential functions of their job. You may get information from the doctor that says there's really only this one or two components of their job that they couldn't do on a regular basis. This may include things like they can't stand for more than X period of time, or they can't be required to, you know, travel as part of their job. But it may be that those either aren't essential functions of the job or at least aren't so essential that the work couldn't be restructured to allow them to otherwise perform their job. So in those cases, leave may still be a reasonable accommodation, but it may not be the only reasonable accommodation. One value of finding out that information is it will help you potentially determine if the employee is just trying to avoid having to return to work when they really could. Once you have that information, ultimately you might be able to make the decision to tell the employee, look, either you come back and do the job that we have available with the accommodations we can make that seem to satisfy what your doctor says, or we'll just have to separate you and you can reapply to available positions that may be open in the future when you're ready and able to work.